Well, welcome back. We're going to have a quick look at the case study from Semester 2 2016's test. Just run over that. Now on this first page, we've got the test itself. The test is on Canvas. Now, to answer this question for the purposes of what we're doing here, although you could use this approach yourself in a test, we're going to use a grid. So the grid has the issue as we identify them. So the first will be, is there a partnership? Then the law. The law is a section, and we want to ask the question, what are the operative parts? Simply meaning, what parts do we need to apply? A brief explanation of them, facts and application, and we'll do conclusions as we go through. So in the case study, we've got Gary, Sparky, and Tom as sole traders who come together to form a business. Now, clearly they've done this in a social context, but they all have businesses, and Gary needs some help with the very heavy gates for the expensive homes. So if we go through to the grid here, the first question we've got to ask is there a partnership? Now, to answer that, we have to start with the basic terms. Firstly, are we carrying on a business? So carrying on a business, we go to section 4. If you recall and go back to the original notes or the recap video, we talked about there being a relationship which subsists between persons carrying on a business in common with a view to profit, creating our 3 elements. So this time we're going to go through those 3 elements. Now, are we carrying on a business? Is there a single business all are involved in? That would be our first issue. Now, when you look through these facts, it's not entirely clear. We have Tom, Gary, Sparky, and Tom doing separate businesses, and you could argue that Tom is and Gary are simply, and Sparky are simply providing services to help Gary. So what do we do in answering this sort of question when it's not entirely clear? You have to set it out and make some assumptions. So Gary's asked Tom and Sparky to help install the gates. They are entirely his product. So you can argue this is not one business. He's only getting their help. Then in paragraph 5, they have their first agreement. Is there one business here? Now, we can argue this, but as an approach to problem solving, we first need to describe it. So we could describe that business as the installation of electronically controlled gates and attached security. What problem we have with this is that it's not at all conclusive. So all you can do in these circumstances are to say, here are the 3 separate businesses, here is a possible combined business. Are they all working together consistently or even one-off on that same business? And we move on to the second requirement. That is whether it's in common. So we talk through what in common means as mutual agency. So do they work for and on behalf of each other? This is also a difficult area to identify facts in. Now, clearly, Sparky and Tom are doing work for Gary. The question becomes, is Gary working for them? So the options are they are doing business for the common good or benefit. Again, this section is quite inconclusive on those facts. The third requirement is a view to a profit. Now we know that's taken to mean an intention to make a net profit. And we've also discussed what that means from a legal perspective. This has a stronger argument than the first 2. Gary and Sparky are sharing the money left after deducting costs. So although it's not really an accounting profit, it shows their intention to have a profit from the proceeds of the business after paying creditors. Tom is not. But in the next paragraph, Tom is sharing the profit. So we also need to turn to section 5, and we look through the presumptions and ask, do any of these apply? In this particular example, the only one applying is the sharing of profits, and that creates a presumption of partnership. So can we then conclude there's a partnership? We have a presumption, so the 3 people are going to have to prove there is not a partnership. We can simply have interim conclusions as we go through these questions. I'm trying to find where I've hidden things. There it is. So there is a single business undertaking they work on, but there is little to show they act for each other. The agreement on profits shows the intention to profit, and I would conclude Gary and Sparky have a partnership, but would certainly accept arguments to the contrary. And Tom later joins the partnership. The strongest argument is that Section 5 says we presume a partnership, and there's not a lot in these facts to rebut or prove wrong the existence of the partnership. So come up to your interim conclusion at that point, and don't worry about it being inconclusive, provided you have identified the issue, set out a brief explanation of the law, and gone through the facts looking for any evidence that would help you to decide if the section applies or not. In our case study, we then had further down this issue of Mitch, and that was in this section here. So they need money for a bigger workshop and they go to the bank. At this point, Mitch is clearly not a partner, but he's introduced to the bank manager as one of the partners involved, one of the four involved in the business of Distinction Gates. Now, we're going to make an assumption here that he's introduced as a partner. Certainly we can argue this point, but we don't have a lot of time in exam test situations to do that. So is Mitch a partner? Now, since he's not a partner but has been suggested to be one, either by his own actions or someone else's, we can start to look at Section 7 holding out. And again, if you've got problems with Section 17, go back to the recap and notes on Section 17. But as a brief explanation of it, where a person says or does anything to make a creditor believe they're a partner, and that creditor relies on this, then the creditor can sue the person as though they were a partner. So we're looking for facts where Mitch has caused or allowed the creditor to believe that he's a partner. So summing that up, we can say Mitch is not a partner, but is introduced as a partner, and he doesn't deny this, allowing the bank to believe he is a partner. This is an example from Section 17 of where a person suffers himself to be thought of as a partner. The bank clearly relies on this and gives credit, meaning the loan, and so the bank can sue Mitch for holding out. The next thing we have is this issue of loans. So there's loans obtained which Gary and Sparky sign. The equipment and truck are bought and a lease is signed for a larger workshop for 5 years. And Tom signs a separate loan agreement for the truck. Are these contracts binding on all the partners? Now we can say at the start, not Mitch because he's not a partner. Now, where do we go? We know it's a contract, so we're going to use Section 8. Our summary of Section 8 is that it requires when a partner enters a contract and it's in the usual way of business, for the partnership, then it binds all the partners, unless that person has no authority and the creditor knows of that lack of authority and or doesn't believe the person to be a partner. So working through those steps, do they exist? Now the contracts are the loan for the truck and for a truck and a lease is taken. We need to describe the usual way of business. Here we can just say it's making and installing gates or security gates or electronic security gates, however you wish to describe it. It's pretty clear these are all within the ordinary business for this kind of firm. It's of the usual way of business and they can be argued on the truck. So you could say maybe the truck's not, but they need premises and transport, etc. So do not get carried away with this. Just make a decision that only one signs doesn't matter. It only requires one partner. Then we turn to the liability issue, which is Section 12. And we know it's joint liability, and that means that all partners are liable for the full amount. That's the three of them. Just making the point here, it's not Mitch. He's only liable to the bank by holding out. holding out doesn't make you a partner, it only makes you liable to that one creditor. Our next issue is the electrical fault, and that's section 13. What does section 13 require of us? All partners are liable for the torts of another if in the ordinary course of business. So it gives us some very straightforward requirements. The key one is, was it in the ordinary course of business? So here we describe it. Does it include installing electrics? Yes, because it's an electronic operated gate. He was doing this when negligent, so all the partners are liable. So a very straightforward scenario. Liable for how much? We turn to section 15. We know it's joint and several. And so the neighbour can sue all of them for $275,000 or sue one of them for the full amount, which is several liability. The next issue is where one of them says, I don't want to be involved anymore. This is about termination. Can we terminate a partnership like that? If there's no term, we use section 29, which in this case there isn't. They haven't agreed how long it will last. So the partnership is determined, meaning ended, by notice of any partner. So then we have to simply say, did he give notice? Now, this can be argued. It's not obvious that he did because the words are quite ambiguous. If he did, the partnership's over. If not, he's still a partner. The agreement's not by deed, so notice does not have to be in writing, but he has to tell them he's ending the partnership. Basically, you decide on this. I would say his statements are sufficiently clear that he's ending the partnership. If he said, I intend not to be, or I will not in the future, then it wouldn't. So let's assume he's ended the partnership. Who gets the truck? It's an ownership and shares issue, as in share of the assets. Now, the truck we're talking about is the crane, not the one that was bought with partnership money. So it's about partnership property. Is this partnership property brought in originally when they form or join the partnership, or brought with partnership money? Now, again, just to make the point that the truck they bought with a loan would definitely be partnership property, but the truck that Tom's referring to is his truck with a crane. So that truck, crane owned by Tom, was not bought with partnership money. Was it brought in? The facts don't tell us this, but it's unlikely. So it's probably not partnership property, but again, you could decide, you might assume they agreed this at the time, therefore it was partnership property. So what would be the outcome of this? In section 27, we have the default rules on who shares in the assets. So if it's partnership property, they share equally. If not, Tom can take it as it would be his separate property. If it's partnership property and shared equally, he gets a share of the sale proceeds, unless they agree to give him the truck. Is Tom right about paying for the lease? In the case study, he said the lease had 4 years to run, and he thinks it's not his problem as only Gary signed it. We have some very bad news for Tom on this. It's a section 8 issue, and we've already dealt with that. But then there's also a section 20 issue in this. So let's just say that the issue was covered under section and 12 above. He is liable, and being the only one who didn't sign it doesn't matter. If we consider section 20, he's liable for debts while a partner. A lease is a long-term obligation, but it was signed at the time. So he was a partner when the obligation was undertaken. So his obligation to pay out the full term of the lease exists at that time. So this grid will be on Canvas alongside the question and alongside this video. So I'll suggest you might want to work through the grid at the same time.